Yes, Mr. Neil.
As a good pleases, my lady, may I just return to what I said about the cell phones? I now checked the record. I, in fact, asked the accused about the cell phone charge, my lady. It's at page 1932, line 10. We have it here. Where I say, and it's page 1932 from line 10 onwards. I made the phone call before I picked Riva up. I put the phone in my pocket. Who put it on the charger? I do not know, my lady. If Carice would say it was on a charger in the kitchen when she spoke on it, how would it have happened? I'm not sure, my lady. So, my lady, what we have there is that he said he spoke on his cell phone before he picked it up, and he put the cell phone in his pocket, and it was later on the charge. He cannot explain how it happened. Lady, may I also then, in my argument, when I argued, my lady, about the first offence, and I quoted ED and Potgieter and those cases, I want to make one other point, my lady. For the court to accept that there was a startle and that the startle caused the exaggerated response by the accused and that he fired shots, now that firing of the shots would have been automatic. It's something that happens, and his own evidence, he said, when I looked again, or I realized I fired shots. But, my lady, that's not true. Because an interesting thing happened, and that's very important, my lady. It was put to Captain Mangena that the accused fired 2 double taps. Later, Mr. Roux had to correct it, saying, I was wrong. It was not 2 double taps. I then cross-examined the accused, and the accused said, I am sure it was rapid fire. I remember it was rapid fire. Now that is impossible. But he felt strong enough to change 2 double taps to 4 rapid shots. It is impossible for his defense to succeed, for this accused to know how he fired those shots, if he acted automatically. That in itself, just that one double tap, rapid fire, just that fact will make his reliance on his first defense crash. It cannot, that on his evidence cannot happen. He cannot explain it, and it cannot happen, because if you act automatically, you don't know what you're doing. So, my lady, I wanted to make those 2 points. Lady, we deal with, at page 72 of the heads, at paragraph 121, my lady, we deal with a summary of the evidence of Berger and Johnson. They were woken up by a woman's terrible screams. It was just after 3 in the morning. The main bedroom window faces Silverwood's estate. Mr. Johnson rushed out onto the balcony whilst they heard a woman scream, followed by a man screaming, help, help, help. Made a phone call at 3:16. After the phone call, he ran to the balcony, and they heard gunshots. Berger heard 4 gunshots, while Mr. Johnson did not count the shots. But what's then important, my lady, is the way that Michelle Berger explained the shots. She said there was a pause between the first and the second and consequent. So she said during the first shot and the second shot there was a pause, and the rest followed rapidly on each other. My lady, it's somebody in an estate having heard the 4 shots, describing the 4 shots, and evidence corresponds 100% with that of Captain Mangena and his reconstruction of the scene. And his reconstruction of the scene, my lady, is, for lack of a better word, common sense, my lady, if you allow me to use that. Because, my lady, if she's standing upright and the first shot, she hits her in A, in the right hip. If there's rapid fire and it B followed immediately, they would have hit her. It's just common sense, my lady. If you talk rapid fire, which is quickly, although she would be hit in A, and although she would start falling, if you look at the door, B on rapid fire cannot miss her. But B did. So, my lady, it corroborates Michelle Burger's evidence on a reconstruction of the scene. Because, my lady, whoever testified here, Dixon, Wolmerans, they were unable to link the bullet holes. Well, they were unable to link any of those bullet holes with a laser to E. Wolmerans said the closest he could get it was through B, but he couldn't get B to E. Now, Captain Mangena did it. Wolmerans was there. Dixon was there when he reconstructed the scene. Captain Mangena managed to put a laser through B into E. He did it in court, my lady. He did it here. He put the tripod exact distance. He managed to put laser through B into E. That conclusively, my lady, shows that bullet hole B missed. Now, if one would say C was the second shot, or D was the second shot, it cannot work, my lady, because we have the fact that the deceased was at the toilet bowl with her head in the vicinity of the toilet lid when she received the shot in the head. It's conclusive. The embedded hair in the tissue on the toilet lid is conclusive. So the court cannot but, with the utmost respect, find that Captain Mangena was correct. That A was the first shot, B missed, and there must have been a pause between the shots, which corroborates Michelle Burger's evidence. Now, my lady, may I ask that the court effects another correction at page 73, my lady, where the record now reads page 3, lines 7 to 20. It should be page 31, my lady. We deal with the one aspect of Johnson and Burger before they knew who committed this crime, before they knew that it would receive all the media hype and attention. They related to their friends. They discussed with their friends. They said, "I'll tell you, I discussed it with that and that and that person, my version," which just gives them the feeling of a guarantee of truthfulness, my lady. In 122, we argue that not only the independent corroboration, but also the demeanor of the witnesses were impressive, supports the argument that they were credible witnesses and that the court should accept their evidence. My lady, one very important aspect is Mr. Johnson, before he made his statement, knew objectively that the 4 shots were fired. They listened to the bail application. He knew it. But still, he stuck to his version that he could remember. If he wanted to be deceitful, who would ever know that he heard five or six shots, but he changed his mind before he made the statement? But he didn't. Well knowing that only 4 shots was fired, he made a statement saying 5 or 6 shots. And lady, that clearly indicates somebody that's not intent on lying. That's intent on giving a version, his version to court. 307. There it is, my lady. Did you know before you made the note how many shots were fired? Yes, I did, my lady. How many were fired? I believe it was 4. Good. Now, if you wanted to incriminate, what would you have incriminated the accused unfairly? What would you have done? The paragraph about the shots. If you wanted to be unfair, if I wanted to be unfair, yes, I'm not sure. You knew it was 4. Yes, I knew it was 4 before I made the note. My lady, that, with the utmost respect, that is incredible. That somebody, knowing that it's 4 shots, will make a note for himself saying that he heard more. That just is a guarantee of truthfulness. That same person had his evidence corroborated by his notes. There is no reason, my lady, to ever reject Michelle Berger or Johnson's evidence at all. It's our respectful submission that the Stips were impressive witnesses. We're dealing with ordinary, albeit professional people living in a security estate who heard gunshots and screams, but nevertheless decided to help. They subsequently made statements, and during the evidence were called upon to recount utmost detail, to provide a minute-by-minute account of exactly what they did. The ultimate question, my lady, must be whether the court is convinced that they were truthful. But, my lady, now, I know that there's lots of criticism in asking this question and answering this question. But I have to, my lady, the Stips, people on the estate, what's in it for them to falsely incriminate the accused or to purposely lie and give false versions? There's nothing in it for them, my lady. And they did not present as people that would do that. The court had the opportunity to observe that. They presented as 2 people that just wanted to tell the truth of what they heard. And they did. My lady, there is, with the utmost respect, no reason. Now, the defense will indicate to the court that there's small discrepancies about where was Mr. Stip when Mrs. Stip was there and which balcony. My lady, those are minute details. But the court got my respectful submission. The court had got a perception, a feeling in observing them that they were good witnesses. Mr. Stip made a statement at the police station. Mrs. Stip didn't even know. When they were at their house, they made statements, they weren't in each other's presence. And they gave evidence. Now, my lady, the one aspect, there's one other aspect. Now, Mrs. Stip gave evidence that, according to her, there was a light in the toilet, and it was on. Now, it was put to her that your husband disagrees with your evidence. It did not put her off. That's what she remembered. She didn't change or said, perhaps I should think about it, perhaps I'm wrong, cannot remember, my lady, I can't recall, my lady. Not at all. So that's how I remember it. that is a guarantee of truthfulness, my lady. If the argument is they're not lying, they were just mistaken. Now, my lady, then two groups of people, two families that never met each other, that lives meters out of 100 meters out of away from each other, made the exact same observations. Now, what's important is 129. Is evidence. She's fluish. She's lying in a bed. She's fluish. She's contemplating, should I get up? Should I do something? I heard 3 which sounded to me like gunshots. I immediately asked my husband, did he hear that? He said, yes, it was gunshots. At that stage, I was sort of sitting on the bed and could see the lights on in the 2 houses that I could see from my bed window, from the balcony window. Now, my lady, her evidence is, with her first sounds, she immediately looked. She's sitting on a bed, and the bathroom light was on. It's Mr. Stipp's evidence as well. If that is true, the accused has just no hope that the court will ever accept his version. If the bathroom light was on, it confirms the state's version that nobody went to bed in that house. Nobody was sleeping. The door wasn't closed, the balcony door. The fan was where it was. The alarm wasn't activated. And that light was on. Now, my lady, may I just ask that we go to 132? Lady, that is Mrs. Stipp's bed. The pillow we see there is where she rests her head. She got up, sat up, and where the red arrow is the toilet window. It's in direct line of sight. There is no way that she made a mistake. When she got up, she heard the sound. She got up, and she saw that. Can I also just see the next photograph? That's just a close-up. Well, from the bed, we could see the bed side lamp, and what would be visible from a window. Now, my lady, there could be argument that the windows were, the curtains were closed, or whatever. Why? One cannot cover all possibilities, and the court would never accept the state to cover all possibilities. What we have a credible witness saying when she woke up, she had line of sight of that window, and at that window where the red arrow is, the lights were on. Lady, if the court accepts that, then the accused version will only on that be rejected. Because if he fired the shots, if it's the first sounds or second sounds, if he fired the shots whilst the lights were on, his version can never be accepted. So, but lady, there's so many things, my lady, in this case that points towards the accused as a tailoring witness with a version that cannot be accepted. Now, my lady, both Stipps heard a woman screaming intermingle with a man's voice. And we argue that the court will accept if one looks at the evidence of Burger, Johnson, and Stipp. My lady, may I just pause here on on what was put to the witnesses, that the accused, when anxious and when his life is in danger, screams with a high pitch and that he sounds like a woman. Well, that in effect is a guarantee of their truthfulness, that they heard a woman. All that the defense would say is, but the woman was the accused. But then we have the difficulty with the intermingling of a man's voice and a woman's voice. So, my lady, let me carry on with the heads and I'll get to that all. At paragraph 136, what the court will find, there was no screaming before the first noises. Now, let me deal with first noises. Let me deal with the first noises of the steps. There was no screaming. But that can never be. Because on the accused's own version, he was screaming like he's never done before, walking down the passage. He was screaming like he's never done before in the bathroom with the open window with line of sight. It was not even put to Stip, my lady, that he screamed before the first noises. Then, my lady, but there was screaming before the shots in the region of 370. That we know. The burghers testified to the screaming of a woman screaming before 317. The Stips testified to a woman screaming. Both testify about the intermingling of a man and a woman's voice. But well, my lady, I will go so far as to say the defense would not argue against a statement that there was screaming before the 317 noises and that the witnesses were not wrong. They heard screaming before the 317 noises. But nobody heard screaming before the first sounds that the Stips testify about. But on the accused version, there must have been. But there was none. Both parties heard a woman's petrified and blood-curdling screams before the gunshots. Because we argue it, and it's our case, that the gunshots were the shots fired at 316, 317. Those were the gunshots. There were no screams after the gunshots. We say the light was on in the bathroom at the time of the first sounds. Now, what is important, my lady, is that both Stips' evidence is the following. The screaming started moments after the first sounds they heard. Not before, but moments after they heard the screams. And those screams ended with the gunshots. Mr. Johnson made a call at 316 and the shots were fired shortly thereafter. Mr. Stip made a call at 315 and the shots were fired after that. Both Johnson and Stip heard the shots fired in the region of 317. Now, my lady, I've read the defense heads and they go into minute detail in trying to pin times down to 312 and there's argument with all these times, my lady. But the fact of the matter is, there were no screams before the first shots. Well, there were screams before the second shot. Both versions, the state and the defense version, one would expect screaming before the shots. Blood-curdling screams as if your life is in danger. That's the accused version. The accused version is, I've never screamed like this in my life. I shouted at them, get out of my house, get out of my house. That's not all. I'm in the bathroom. I screamed. Nobody heard it. Stip was awake. Mrs. Stip was awake. Nobody said to her that she wasn't awake. But why would anybody? Some lady, there is more than enough reason. And Berger's evidence about the 4 shots she heard, she counted them. It was 4. The Stips counted 3. But that is expected. They counted 3 shots, 3 sounds initially, they counted 3 shots later. The one person that we know that counted 4 is the one person whose evidence is corroborated by Chris Mangena. Is corroborated by the objective facts. And she heard 4. And she explained why she heard 4. But lady, our argument is that the shots were the shots fired at 3:17 in the region of 3:70. That the screams were those of the deceased. That if the court rejects the accused version of the scene, but it becomes so much more probable that it would have been her screaming, because if there's no perceived intruder, she found herself locked up in a toilet. And that's probable that she screamed in getting there. Because why would she find herself locked up in a toilet if there's no perceived intruder? Because there was none. So, my lady, our argument is that the court accepts our case, that those were the shots. My lady, then, as far as gastric content is concerned, Estelle van der Merwe testified that at 1:56, she heard a woman's voice, and she made the inference that she was involved in an argument. Lady, now, in the way that I've read in the heads of the defense, they tend to make this one continuous happening. She heard sounds all the time from 1:56 to the sound, to the shots, and it then stopped. That's not her evidence. Her evidence is, I tried to block it out. I tried to block out the sounds. I put a pillow on my head. The way I read the evidence, my lady, is that she almost fell asleep and woke up again when she heard the shots. She heard the argument from 1:56 going on and on and on. And then later, and the way I read it, and I'll check, and if I'm wrong, I'll put it I'll make sure that I give the correct version to the court. My reading is that she woke up and then heard the shots. So, my lady, now.
Well, was she not in and out of sleep?
In and out of sleep,
Yes.
indeed. In and out of sleep. And when she when she woke up again, she heard the shots, and she tried to block it out. You're 100% correct, my lady. But may I just confirm?
Yes, please.
Yeah, it's confirmed. It's page 161, but the court is 100% correct. My lady, then, if the defense in the argument would say that she heard somebody crying, and that must be the accused after the shots, then that must be admission that she can hear things from them, and on that day. Because she heard a woman cry. Now, to say that the crying she heard was also from the same house, because she heard the accused, must be an admission that it's possible. But, my lady, it just worked out brilliantly, in the sense that on the 21st of February 2014, there was somebody at the house doing something. at the accused house. It's a year later. And she picked it up again. And what's even better, my lady, is in both occasions, on the 14th of February 2013 and on the 21st of February 2014, she first got up and looked to the side of farming. That's her evidence. On both occasions, she looked in that area. On the 21st, having now been through this, having been consulted, having made statements, she made sure that to look at the house of the accused, and there they were. The sound she heard on the 21st, after she first looked in the area into the direction of farming, was at the accused house. That's just a further guarantee of her truthfulness. She never once tried to say, to link it to the accused house. She never once did it. She just said, I heard a woman, and that's all she did, my lady. But, my lady, 5:20. My lady, the evidence of Professor Simon. Now, my lady, I will argue that Professor Simon is the most impressive witness, is a witness that gave evidence that the court will accept. I say in the paragraph, I'm not going to even try and summarize his evidence, because the way he gave it, my lady, was just impressive. Now, if that is true, if what he said there, my lady, all things considered, to the extent that I may have an understanding thereof, I would think that it would be very unlikely, unless an exceptionally large meal had been taken, it's likely that the food we see in the stomach of the deceased had been introduced within approximately 2 hours of a death or less. In other words, 2 hours prior to her death, she probably ingested this food. And my lady, I will go through that. But if the court accepts that, and there is no reason, with the utmost respect, my lady, not to accept it. If the court accepts that, that corroborates Van der Merwe's evidence. That heard a woman at 1:56. If it's 2 hours before 3, it's 1 o'clock. It could be earlier. There will be argument tomorrow that that could be stretched back to 11 o'clock on the 13th. Be it as it may, there are two important things. The one is, it corroborates Van der Merwe's evidence. The other is, it destroys the accused's evidence that they were sleeping from about, let's give him the benefit of the doubt, from about 10 until the time that he woke up at 3. Somebody ate. She had something to eat. But she did not eat upstairs. Because I agree, there are no plates in the room. If she ate, she went downstairs to eat in the kitchen area. That indicates, my lady, that we don't have a couple sleeping from about 10. We don't. We have people awake. So, my lady, we say in paragraph 147 that what the court should do is to follow the approach in Ardeb, which is step back and evaluate the mosaic as a whole. Because there'll be excuse me, there'll be argument that if you apply Blom's case to the evidence of Van der Merwe, you have to apply the two legs. Is this the only reasonable inference? Does it correspond with the facts? And if you apply Simon's evidence, you have to apply the two rules in Blom. It's not like it. What you apply, my lady, with the utmost respect, is you apply the Ardebe principle. You stand back and you look at these two circumstantial evidence and you see, yes, indeed, it corroborates each other. It corroborates the fact that the lights were on by a stip because the people weren't sleeping. It corroborates the fact that the police found the scene as is. So it is much wider, Malay, than applying the Blom test. Then the defense put to Van der Merwe as well. Just 148, just open it. He says, but from your balcony, his bedroom and his balcony door and the bathroom, even all of them, are right on the opposite of this house. So, just go up. So the house of Oscar Pistorius that you are looking at, that's the front side. The bedroom is right on the other side, with the bedroom opening the balcony from the side furthest away. Is that correct? Then it was put to the witness that it would be impossible for her to hear. If it happened in the bathroom or bedroom, I don't know, she heard something. Lynn said one should look at the listener. But if it happened downstairs, then they're much closer. Can we just have a photograph? Downstairs, she is where 180 is, my lady. The accused's house is indicated with an arrow. Downstairs is the entrance there where the arrow is a bit more to the left. So, my lady, but whatever. This is really going into minute detail. What we have the following. We have, at 2 o'clock in the morning, Van der Merwe waking up, hearing a woman argue. Is it mere coincidence that at that same time, a woman somewhere else was arguing, and that on that same day, the deceased was shot and killed at 3. At that same day, or not the same day, but in the same time, the deceased must have eaten something during the same time. Is it mere coincidence? It just cannot be, man. Cannot be mere coincidence. Now, the defense had available to call Dr. Perumal. Now, he was present during the post-mortem on behalf of the defense. They decided not to. Tellingly, they called Professor Botha, who was not at the post-mortem, who had to give evidence based on the report by Professor Simon. Well, lady, it's one of those things that you have, and I'm not admitting, I'm not saying it, but let us say you have two very good pathologists. One was present and, in fact, did it. He did the post-mortem. The other one just reads his report, haven't seen the gastric content, but now wants to make inferences from what this person saw and what this person did. Lady, it just cannot be. The one that did it is in so much better position. My lady, I said that I don't want to summarize the evidence. May I just refer the court to page 517, line 7. So there was food residue visible in his stomach. Would you care to comment on that? Then he started with his comment. Yes, my lady. I think it's important to point out that in response to a question of this nature, the first answer should be that this is not an exact science. He says it, my lady. He said, this is not an exact science. I know that. In other words, there are varying time frames that may be implicated. We clearly can guide the court to some extent in terms of probabilities. But I think it's important that the court appreciate that there may be inter-individual variations between myself and someone else, but there may also be intra-individual variations. In other words, if I eat the same kind or amount of food today as opposed to a week from now, under different sociological circumstances, physiological, I just can't see there. The emptying time of the stomach and the digestion time of the stomach may be different. So there is significant variation, but there are indeed fairly good timelines which have been established from a physiological perspective. One of the reasons why this particular topic has been well studied in medicine is primarily because surgeons and anesthetists do not like to operate on people that have recently had something to eat, because this can compromise the patient if they were to have foodstuff in the stomachs and they were to regurgitate or aspirate this food. But it goes on. I'm not going to read it all, because that I read to both Lindgren and Botha, and they agreed 100%. We have here a witness saying, I know all that. I know it's not an exact science. I know the variations. I know that. But based on my experience, based on what I've seen, this is my view. He's an expert. He based his view on his expertise, at least, that he's a pathologist, and the court will accept it. If the court accepts, my lady, that she had eaten within 2 hours of a death, the accused version will never be accepted, whatever his defense is. Because in his version, there's just no place for the accused or deceased having eaten. They slept. And then, my lady, because we have this tailoring of evidence, the accused, in having testified that he activated the alarm, had to exclude the fact that she could get up at night, deactivate the alarm, go down, go eat something without him waking up. That did not happen. That did not happen. Similarly, if we have... May I just deal with Professor Lundgren as evidence? The issues as far as her evidence was concerned is that she never realized that the stomach content had been measured. When it was put to her that it was 200 milliliters off, she didn't know that. She wanted to be shown. We shown her. We then just took evidence by saying that she would expect 4 hours, if somebody ate 4 hours before an occurrence, that there would be 10% food left. And then we made all those calculations. So her problem was that she didn't know. And also her problem was that she would identify various factors that may have played a role. And she's right in identifying those factors. But she couldn't apply it to this case. And nobody can. So it's not good enough for the defense saying, because Professor Lundgren identified possibilities that may have affected gastric emptying, therefore the court has to take it into account, and the state has not proven beyond reasonable doubt that she had eaten 2 hours before. That cannot happen, my lady. You cannot think of any possibility. You must link it to something. You must apply it to something. You must apply it to this case. And there the defense failed. My lady, the one further aspect is paragraph 161. We argue that the value of Professor Lundgren's evidence faded into insignificance when you take into account that digestion does not stop post-mortem. It's not the same, but Professor Simon explained exactly that the enzyme keeps up digesting the food and so forth. Now, and we also then indicated that she was only admitted to the where was she admitted? To the mortuary. That's the word I'm looking for. I just couldn't get that word. She was admitted to the mortuary or taken up into the mortuary at 11:45. And so, my lady, Professor Lundgren's evidence cannot be accepted that one will be able to say that the gastric content is as a result of a dinner they had between 7 and 8. It just cannot be. Then at 164, we do just that. We say, if the court steps back and considers the mosaic as a whole, there's no evidence that the deceased ate something in the bedroom. She must then have eaten something downstairs. We say that if you look at the photograph, she's closer to the Van der Merwe's residence. And this inference also shed light to the accused struggle to deal with the deactivation of the alarm. The only reasonable inference to be made is that the alarm had not been activated at all. We argue, my lady, that the court will have no option but to find that the deceased had eaten between 1 and 3:17 on the morning of 14th February. And there we deal with the finding in itself does not only corroborate the inference that Ms. Van der Merwe heard the deceased's voice from around 1:56, but it destroys the accused version of a loving couple going to bed at approximately 10. My lady, if I deal with the relationship. In this matter, the state succeeded, my lady, in giving the court a glimpse of what we call the real relationship that existed between the accused and the deceased. The defense led to evidence of Mr. Van Zyl, and as we anticipated, rely on the opinion of Dr. Scholes. But, my lady, we were lucky enough to have the deceased view of this relationship by means of a WhatsApp. Whatever the accused would tell Scholes or whatever the accused would tell Van Zyl, that's his view. What we have here is we have the view of the deceased in long WhatsApps talking about their relationship. We say there, my lady, the defense would say 90% of all those messages, we read them all. Boo boo, ba ba, cross, 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 kiss, kiss, kiss. That's true. It was there. But, my lady, I can do no better than to quote Mr. Carr, a clinical psychologist, who said, it's the 10% that matters. It's about like saying, you only have cancer in your lung, but it's a small part of your body. It's that 10%, my lady, that counts. It's a 10% of the WhatsApp messages, less than 10, 2%, that really counts. And that's not all. What really counts, my lady, is the timing of the messages. We're not talking about messages that's years old. We're talking about the message 14 days before the murder, 27 January. Talking about messages, 27 January, 7 February, nothing improved, or there's a problem again, and argument, if one relies on Van der Merwe's evidence, and the killing of the deceased a week later. That is important. Those boo-boo, baba WhatsApps, my lady, of earlier and during is not that important. Because it indicates two people talking to each other without really talking to each other. These two WhatsApps that we have is where the deceased opened herself up and spoke to the lady. Now, also, when Mr. Van Zyl testified, we were able to hand in the email written by the accused to the Taylor family. Now, that email is significant. It's a long email. There's lots of things in that email. But if we take out one thing, that it's not, as Mr. Van Zyl said, that Riva was the first person he wanted to take anywhere. He wanted Samantha Taylor in London. It's in that email. It's in that email how upset he is about the broken relationship. So, my lady, it's not what the defense would want the court to believe that this was the one. But now the defense argues that the court should admit the statement of Gravenstein in the bail application in terms of the Hearsay Act as part of the evidence without even venturing a reason why Gravenstein wasn't called. Now, my lady, if you deal with the Act on Hearsay, the first thing you do is you say why this person cannot give evidence. Before you deal with the merits, you tell the court, I want to admit a statement, and the reason why I want to admit the statement is because this witness is not available and because, therefore, I want to do it. No. Gravenstein, I don't know if she's available. I think she must be. But there's nothing in their argument. But, my lady, it's the most amazing argument. It's saying, Gravenstein's statement, affidavit, was handed in the bail application. She was never cross-examined. She never gave evidence. Please, without ever subjecting her to cross-examination or testing of a version, allow that in the trial as well. No, the court will never do that. So we have an untested affidavit by somebody that must be available, that we don't know if she's available. The court will not do that, my lady, with the utmost respect. My lady, if one, as I said, and I'm at 175, the dates of the messages, my lady, I won't read the whole messages, but may I just refer to them in passing, 27 January. My lady, we know that the accused will have and will in argument give his view on how this should be interpreted. Unfortunately, we cannot call the deceased to say how this should be interpreted. We only have what she wrote. Now, I'm scared of you sometimes and how you snap at me and of how you will react to me. You make me happy 90% of the time. I think we're amazing, but I'm not some other bitch you may now trying to kill your vibe. That's a reference to the song that was played. But that's what she said, my lady. Can we go on? I think it looks like we are a struggle, and maybe that we are. I just want to love and be loved. Be happy and make someone so happy. Maybe we can't do that for each other, of course, right now. I know you aren't happy, and I'm certainly very unhappy and sad. That is the 27th of January, my lady. I will read just one portion out of the next. I thought it would make a difference in us getting out without you being harassed anymore. I didn't think you would criticize me for doing that, especially not so loudly so that others could hear. I'm trying my best to make you happy, and I feel as though you sometimes never are, no matter the effort I put in. Lady, I know that the defense would argue at length about the brilliant relationship. And even from the WhatsApps, I read them. 90% of the times you make me happy. But, my lady, we have 27 January, 7 February, she's unhappy. She is explaining it, why she's unhappy. And then we have 7 days later that she was killed.
But, Mr. Nell,
yes, madam.
Can you really rely on these WhatsApp messages? Can you really make a proper inference one way or the other?
My lady, with the utmost respect, yes, my lady, because we just read what she wrote. She wrote it. It's not in dispute.
No. I hear what you're saying, but aren't relationships dynamic?
Indeed. Indeed.
Yes.
Up and down.
The
No
fact
problem.
that you are unhappy today doesn't mean tomorrow you won't be.
Indeed.
You
But
know,
the
you'll
fact-
still be unhappy. It may change.
100%, my lady. I cannot argue against that. The court's correct. But, my lady, what we have is, we have I'm unhappy 27 January. We have I'm unhappy a couple of days later, 7 February. So nothing improved in that time, and we know that that relationship ended when she was killed on 14 February. So, my lady, what I'm saying is, if one takes into account the time, the dates of these messages, that is important. It's, my lady, between 27 January and 14 February, there will be lots of other loving messages, no problem. But I'm saying, my lady, one has to interpret these WhatsApp messages. And that's just my respectful argument, my lady, that one has to, because it happened shortly before this incident, and our argument is that this incident led to a killing after an argument. And all the facts show that. So, my lady, in that sense, I say one has to. That's what we have. Because what we have, apart from that, we have the accused saying that they were happy. We have Dr. Scholz, who saw the accused, that said, as far as his opinion is, they were happy. And I'm not saying they were unhappy. I'm not saying that. I'm saying they weren't without problems. And at least if the court will accept they were not without problems, and that problems, because we've got all the WhatsApp, that problems started on the 27th of January in that area, not before. And it's not a normal couple. It's not one of those normal relationships. This relationship ended in death. 17 days after the 27th of January. I became a lawyer because I can't count, my lady. So it's 14 and 5, 19 days, my lady. So that is why it's important. So, my lady, that's my answer. As far as the WhatsApp goes. We say, my lady, that the accused version is that we have a loving couple that spend a quiet night together on Valentine's Day. We say there's not even a suggestion of intimacy. They were kissing, were lying on the bed. But that doesn't fit the objective facts. And we say at least the WhatsApp messages, in fact, paints a different picture of the nature of the relationship. Lady, if I deal, and I will not deal in so much detail with the other charges, but I will just deal with it. I would like to get through to our conclusion, my lady, and spend more time at the conclusion before the end of business. So what I'll do now is I'll run through the other charges and get to the conclusion. Now, my lady, as far as the other charge are concerned, if we start with count 2, it's the firing of a shot through the sunroof. There again, my lady, we're not saying that there are no contradictions between the evidence of Samantha Taylor and Darren Fresco. There were. It's expected. Except if those two got together and decided to falsely incriminate this accused about what happened, one would not expect contradictions. But, my lady, they came forward, different occasions, gave affidavits of how they remember this incident. But what they remember is that he fired shots through the roof. Now, my lady, it just makes sense that if you decide we will now incriminate him, you will definitely know what happened before, what happened after. But there were contradictions. We're not saying there weren't. But they both testified that the accused had an argument with a Metro Police official after the policeman had handled the accused firearm. He agrees that happened. They agree that the accused fired a shot through the sunroof and he laughed about it. They both said that on that day they visited an address where the accused had seen someone about gun or had to sign papers relating to firearms. Now, my lady, apart from that, he said they both lied. He denied the fact that they visited the house. Now, this is one of those cases, one of the counts, my lady, that the court will either accept the state's version or the accused version. It's just that cut and dry. But let us just, as the court should do, evaluate the probabilities of the two contradictory versions. I don't think it's in dispute that if one accepts Mr. Fresco's evidence and if one looks at the place where the shots were fired, where he pointed out to Captain van Aard, it was in a public place. But let us just look at how the accused dealt with his firearm that particular day. He went to a party that day. He was on a boat. He had his gun, on his version, between his legs, driving. Or was that Fresco's version? But while swimming, he dived in, but he left his gun on a boat, under a towel. He left his firearm on the front seat of a car, clearly visible where the Metro police officials found it and had free access to it. We deal with the fact that there is no conspiracy between the witnesses. We argue that the incident happened. The state witnesses gave the recollection of an event months after it happened. They never reported it immediately. It happened months later. But, my lady, to criticize Samantha Taylor for not knowing where this happened is, with utmost respect, not fair. She made it clear, I don't know where we were. I know we were driving. I never took note. I'm sitting in the back of the car. She's not saying that. I'm saying. She's sitting in the back of the car. She doesn't know where they're going. They said, now the house, can you direct us to the house? I said, I know what the house looked like, but I can't take you there. I can take you there, but I can't tell you where it is. Samantha testified that she was uncertain where the shooting incident took place, where they were pulled over by Metro Police, and where the house was that they visited. But everybody agrees that they were pulled over. She contradicted the evidence of Mr. Fresco on the sequence of events, that the shooting incident happened before or after the visit to the house. And there's also this contradiction where she testified that the accused had wanted to shoot at robots. Those are contradictions. But where they don't contradict each other, that he did it, that he fired through the roof. We argue that the incident happened. We respectfully argue that the contradictions, in fact, provide a guarantee of truthfulness. If the witnesses had conspired to falsely incriminate the accused, the court would expect no contradictions in their evidence. It was never put to them that they, in fact, conspired to falsely incriminate the accused. Count 3, my lady, is a clear indication of the accused's inability to take responsibility for his actions and his habit of hiding behind the phrase, I can't remember, tailoring of his versions and blaming his own counsel. That all happened. As far as this count is concerned, there's very little in dispute. The accused admitted in his plea explanation that whilst I was in possession as alleged, a shot went off. So we know that. He had the gun when a shot went off. The gun discharged while he was in possession of it. Lady, that should be the end of it. The accused admitted we were both negligent, my lady. I should not have taken the firearm under the table. The accused admitted that the gun was discharged in a restaurant full of patrons. There were lots of people there. That's correct. He further acknowledged that there were children sitting at the table next to theirs. My lady, the accused then stated, I did not discharge the firearm. That is why I pleaded not guilty. He later expanded by testifying that he physically did not discharge the firearm. The firearm went off when it was in my possession. I do not remember having my finger on the trigger. Now, my lady, then we led evidence by the expert, Captain Mangena, saying that that firearm cannot fire. It has the safety mechanism on the trigger. You have to have your finger on the trigger for that firearm to fire. Fresco said the same. He said, it's my gun. I know the gun. It cannot fire without you pulling the trigger. My lady, there is just no other inference of finding that the accused pulled the trigger and that a shot went off. But he is adamant. Now, my lady, when in reading this, it reminds one of his defense on the main count, saying, when I realized I fired 4 shots, the gun just discharged, shots were fired, I never pulled it, but I had the gun, and it went off on its own. The court will not accept that. Not after the owner of the gun said, it cannot discharge unless the trigger is pulled, not after Captain Mangena testified. There will be saying it's possible that the gun malfunctioned, or it's possible that this happened, or that's not what Saul said. As what Saul said, the court should just look at what is reasonably possible. It was never put to Captain Mangena that gun could fire without having a finger on trigger. In fact, he denied it in his evidence. He said it cannot fire without having a finger on the trigger. The owner testified that the gun will not fire if the trigger is not pulled. It was never put to Fresco that gun fired without the finger on the trigger. It was never put to him. And, my lady, the accused never ever said, what happened? The gun just went off. He's a gun enthusiast. He never discussed it with anybody. That gun just went discharged without him touching the trigger. In paragraph 203, we say one would have expected the accused to have immediately told everyone that the gun had just discharged itself for no apparent reason. As a firearm enthusiast, one would have expected him to have discourse with Mr. Fresco and others on this extraordinary and potentially hazardous phenomenon, that the gun would just fire. But no. He's more focused on keeping the facts out of the media. There is just no evidence that he ever mentioned, and he said he never discussed the fact that gun discharged without his finger on the trigger with anyone. And then we deal with his version. His version is when we tested him on the fact that he would have discussed this with other gun enthusiasts or anybody. It must have bothered you that the gun went off on its own. Yes, it did bother me. When we pressed and carried on the improbability that he did not discuss it with others, his version changed to, it did not bother me that the gun went off by its own. Later, it bothered me that the gun went off in my possession. Press further, I do not think I ever thought of it as a gun going off without me pulling the trigger. And then at the end, after all that, did it bother you that the gun went off on its own? Yes, it did. Lady, it's a tailoring of a version, vacillation between answers. The accused is just incapable of taking responsibility or giving a true version to the court. He is incapable of doing that. although the accused tried to avoid answering the questions whether it bothered him, he definitely failed to explain why he did not mention it immediately after the incident or discuss it with anyone. The more likely response would be that he was amazed that the gun had gone off on its own, but he elected to allow Fresco to lie, and in so doing diverted any adverse attention to him. But it just didn't happen. That gun cannot fire without somebody pulling the trigger. He said he was in possession of the gun when a shot went off. Now, that in itself, my lady, is discharging of a firearm. He was in possession of it, and he discharged. For purposes of this count, we say that's enough. But we go one step further. That gun, the Glock, cannot fire, my lady, without the finger on the trigger. The safety mechanism is built into the trigger. He pulled the trigger. As far as count 4 is concerned, my lady, again, the true nature of the accused came to the fore. He is a gun enthusiast. He wrote competency tests. He knows what you're allowed to possess and what you're not allowed to possess. As far as this case is concerned, it was again accused trying to blame his counsel and trying to explain what answers he got from counsel about his understanding of the law. But what's not in dispute is the accused admitted that the ammunition was found in his safe. He admitted that at all times relative to this count, I had not been issued with a license to possess the .38 caliber rounds of ammunition. He said, and we say it's not a viable defense. The ammunition belongs to my father, and he, the accused, agreed that his father could put the ammunition in his safe. But there's argument and reference to joint possession cases in robbery cases where the one robber would have a gun, the other one would shoot and kill somebody. We're not saying this is joint possession at all. He possessed it. It's his safe. For purposes of this count, it's closer to possession of cannabis. If you're in possession of it, it's yours. He's in possession of those .38 ammunition. It's his. He should be convicted.
I think the defense mentioned something about having animus.
But he has,
that it can't be possession only, that you've got to have animus.
No, my lady. It's possession only. You don't need animus to possess it. Why would you, if you're not a licensed holder, why would you have that? My interpretation of this is it's strict. You're not allowed to have ammunition if you don't have a license for it. But even with animus, the animus is to possess, not to use. So if I possess it, if I keep it for somebody, that's enough. Not to use, and it should never be I can only be convicted if I have that for my own use and to do something with it. It cannot be, my lady. Because the legislation is clear and strict. You're not allowed to have it if you don't have a permit. So if your intention is just to have it, not to use it, just to have it, then you're guilty. And that was his intention, to have it, although he said to have on behalf of his father. He had it. So, my lady, he is guilty. Then, my lady, if I can deal with the conclusion. it's not our intention, my lady, to bring conclusion to our heads of argument without. We would try not to duplicate any of our arguments. It's difficult, and we might do so. We return to the metaphor of the relay race. If the accused started the race with a baton, and that baton he had to hand over to somebody, he wouldn't be able to do that because he stumbled and he fell, and he dropped that baton. The baton of truth is not with him. He cannot complete this race, my lady. And he should only blame himself. If in a relay race you drop the baton, you're disqualified. The accused disqualified himself from his version being accepted by the court. Now, if the court, my lady, rejects the accused's version of events, and the court relies on the objective, the common cause fact, and the circumstantial evidence, a conviction on murder with dolus directus is inevitable. I've dealt with that, my lady. They were alone in the house. He shot and killed the deceased just after 3 on the morning of February 2013. He fired 4 shots with deadly black talon ammunition. The shots were grouped, is our argument. The deceased locked herself in the toilet and was fully clothed when she was shot. The first shot hit her while she was standing upright facing the accused. Now, my lady, there might be argument, and I'm just anticipating it, that if there was an argument, she would have been scared and she would have, in any case, hidden herself in the toilet. If there was argument between her and the accused. But, my lady, if there's argument and she fled and she locked the door and he's outside and she's inside, I don't think, with the utmost respect, based on the state's version, that she expected to be shot. So why would she, if the only other person in the house is the deceased, the accused, why would she hide herself? I don't think but if she had any idea that there were other people in the house and they were intruders, then she would have hidden herself. So, my lady, we say, even in the event of the court accepting the accused's evidence that he thought there was an intruder in the toilet, he cannot escape a conviction of murder with dolus directus. My lady, if the court accepts that he thought there was an intruder, and he's standing in front of that door, and he fires 4 shots into that small toilet cubicle, what? I'm asking a rhetorical question, I'll deal with it. Why would that not be dolus directus murder of the intruder? Because there is just no attack on him. The intruder is behind a closed door at the least, behind a closed door. He's in charge. He's armed with a high-powered firearm. Why would that not be dolus directus? But I know the arguments. I read the arguments of the defense. It's not a aberratio ictus. It's not that the deflecting of the blow and how one has to deal with it. It's not. It's error in objecto. Now, my lady, may I just refer the court? It's its name on the 5th edition, page 193. That's the one book, my lady, I had to bring and I didn't. But it's dealt with there, and it's not even half a page, my lady, where error in objecto is discussed, where it's clear. Oh, my lady, Captain Muller found it, and I'm so glad. (193). What is the position if X intended to shoot Z, but it subsequently transpires that he mistook his victim's identity and in fact shot Y? Here his mistake did not relate to whether it was a human being he was killing, but to the identity of the human being. Murder is committed any time a person unlawfully and intentionally kills a human being, and not merely if a person kills that particular human being who, according to his conception of the facts, corresponds to the person he wanted to be the victim. For this reason, X, in this case, is guilty of murder. His mistake about the object of his act, error in objecto, will not exclude his intention, because the mistake did not relate to an element contained in the definition of the crime. So, my lady, and what we also did, my lady, in drafting the indictment, we made it clear that the accused intended to kill a human being. Then we said, to wit, in this case, he killed Riva Steenkamp. But the charge sheet, the indictment reads that he intended to kill a human being. Now, his intention when he fired those shots was to kill a human being with dolus directus. Lady, now, if it's not dolus directus, objectively, there was no imminent attack. Subjectively, the accused armed himself and approached the danger by walking down the passage toward the bathroom. He was ready to shoot. Upon reaching the bathroom, realizing that the intruder was in the toilet, he continued to fire 4 shots into the toilet cubicle. We argue that there was no reasonable event that would have caused a perception that an attack was imminent. The perception must be based on something reasonable at least. It's a subjective test, that is fine. But it must at least be something reasonable, something the court can understand. If one totally unreasonably think that that person is going to attack me and shoot and kill that person, that can never be a defense. Although it is a subjective test, it must at least be a reasonable event that caused it. We argue, my lady, that the accused cannot escape a finding of murder with dolus eventualis. If you fire 4 shots into a small cubicle with a high-powered firearm, with black talent ammunition, you foresee the possibility that you will kill somebody, and you continue doing that. You reconcile with that foreseeability, and you continue firing. He cannot escape that. We say it's dolus directus, but he cannot escape it. He never said to anybody that it was an accident, that he never wanted to shoot, that the shots went off by mistake. He said he thought she was an intruder. It's the only reasonable inference. If one rejects the version of the state that he knew she was in the toilet, the only other reasonable inference is that he thought there was an intruder in the toilet. And if he thought there was an intruder in the toilet, he's guilty of murder. Dolus directus, at the least dolus eventualis, for killing the intruder. Error in objecto is not a defense. Vormerans testified there was sight alignment. My lady, what's important though is to also take into account the angle of those shots. Those shots were all angled towards the toilet. Now, we at a stage put to him that he moved the shots because he followed the sounds he heard when she fell onto the magazine rack. And why is that not a finding that the court can make? Because he is the person that have to explain to us why that angles were there, why he fired in the way he did, and he did not. My lady, then, if the court would accept that the accused acted in putative self-defense, then he cannot escape a conviction of culpable homicide. Not whatsoever. The objective test, and there's lots of discussion about the objective disabled man and how he would have reacted. But what we have and what the court cannot lose sight of, we have the accused armed and ready. That is the reasonable man. Is a reasonable man standing in a bathroom looking at a toilet door, armed and ready to fire. If that person is disabled or not, the fact that he is armed is the fact that the court should take into account, and that he has his firearm pointed towards the door. Now, a reasonable man, a disabled man, reasonable abled man, a reasonable woman, a reasonable whoever, will not fire. The court will not accept that that person would fire without cause. Now, what we have here is there was no cause. Nobody came out of the door. What we have, objectively, we have an unarmed, vulnerable woman shot and killed in a toilet. That's objectively. That's what we have. Objectively, we have an unarmed, vulnerable woman that was shot and killed. So, my lady, as far as objective test is concerned, it's not the objective test of a disabled man that cannot get away, that's acting. We have a disabled man with a firearm ready to shoot. It would have been different, my lady, if that door opened and he fired. Because then at least there's something, some objective instance that the court could look at. But we don't have it here. So, my lady, he cannot escape that. Now, as far as pre-planning is concerned, my lady, we refer to Monch's case, and we agree that pre-planning is a deliberate weighing up of the proposed criminal conduct as opposed to the commission of the crime on the spur of the moment or in unexpected circumstances. Now, my lady, what we have here is not the accused is armed, something happens, he pulls the trigger. We don't have that. We have, I have to remember where I put the firearm. That's the first thing. I have to go there. I have to look for the firearm. I have to get the firearm. I have to unholster the firearm. I have to get the firearm ready to fire by at least disengaging the safety mechanism. I have to walk at least 5 meters with the firearm at the ready. I have to take up a position, and then I have to fire 4 shots into a toilet cubicle. And if there's a bonus that there's a good grouping while firing, then it is pre-planning. Lady, now, there'll be lots of arguments saying pre-planning means you have to sit and work it out, and the court, I think, dealt with it brilliantly. The court said the period of time between the accused forming the intent to commit murder and carrying out this intention is obviously of cardinal importance, but equally does not provide a ready-made answer to the question of whether the murder was planned or premeditated. May apply to the facts on the state's version. My lady, if the court rejects the accused version, if the court rejects the fact that there was a perceived intruder in that house, then the accused armed himself, got the gun ready, walked to the bathroom, shot and killed the deceased. Not in the spur of the moment. I mean, he had lots of time for reflection. He made up his mind in the bedroom when he armed himself. I don't know when he armed himself, but he made up his mind. That, my lady, is pre-planning. Not pre-planning for months, But at least when I arm myself and I plan to kill and I get there and I kill, then I planned it. So, my lady, that's what we're saying, that the accused pre-planned it. We say, my lady, our conclusions are based on the objective facts. If the court accepts that the deceased had eaten within 2 hours of her death and that a voice was heard by Ms. van der Merwe, then finding murder, those directives will be even more inevitable. The court accepts that the bathroom lights were on when the deceased fired the shots. We respectfully argue that he cannot escape a conviction on murder. So, my lady, our argument is that the accused should be convicted on all the counts. As a court, please.
Thank you. Yes, Mr. Roux.
My lady, the court would give me an indication as to the times that the court will sit. I see it's 3 o'clock.
It's 3 o'clock.
Yeah. So we have two options, one to go a bit later, or the other one is possibly to start at 9 o'clock to
At 9 o'clock.
make sure that we don't intrude on your Sunday.
Okay.
I may say you refer to reply, and I may just refer to Section 175 of the Act. The state has no right to reply on the facts. Only with leave of the court. He can reply on law. But I may say in the same breath, we gave them all our cases and the heads before the time we should have. So I cannot see that happening.
Yes.
So sensibly it should be us tomorrow, but if the court would consider 9 o'clock, that would assist, or alternatively sitting half an hour later.
Can we sit until 4? I mean, 3:30. Suzette? We can sit on another half an hour.
Thank you, my lady.
Yes.
My lady, I think that before I deal with the heads of argument, just to hand to you pages, there were some problems, typing problems on pages 205 to 208. We have amended pages available with punch holes in. If you would kindly just replace that. Thank you, my lady. And then also, before I turn to our heads of argument, maybe just dealing with a number of material mistakes made by the state in its address, and maybe we should just highlight some of the difficulties. The one thing we would ask the court when the court considers our argument is, we know on the facts that Dr. and Mrs. Stipp, and to some extent Mr. Slingetwa, heard the first shots. And then the second sounds, that's also described as shots, were then heard by Dr. and Mrs. Stipp again, and then Mrs. Berger and Mrs. Johnson. And we were waiting for the state to tell the court what were those first shots. And you will not find the answer in his heads of argument, and you will not find the answer in his argument. And one thing you cannot do in a criminal trial, you cannot ignore a serious, material, objective fact. You cannot do that. And the state has done it. I know why the state has done it. Because it will cause a nosedive of their case on the 317 description, what they described as shots. They also don't deal with the cricket bat striking the door because they cannot. But we'll deal with that. The second point is this, my lady, and that is the state started off by submitting to this court that he's so reckless with the firearm. Look at September and look at January, and now, of course, again in February. There are two difficulties. The one is we refer in the heads of argument to De Bruyn's matter, saying, there was previous case Kanyapa, and it overruled it, the Supreme Court of Appeal, to say you cannot take a conviction of the other counts into account for purposes of the murder in this case. You cannot do it, but we'll deal with that. So the state cannot do that. The second point is that it was to some extent called a presumption of continuance that the authors in all the books dealing with the law of evidence will work with and warn against that. And the state also very subtly tried to apply that. How the so-called presumption of continuous work was, you see a man or a person driving fast, and 2 kilometers further, you don't see him all the way. There's an accident, and a whole question then arose. Can you say because he was driving fast here that the speed was the cause of an accident later on? And there's a warning to say there must be a nexus between them. Unless you can have that nexus, you cannot apply that so-called presumption of continuance. And that's what the state really tries to do. He says, because of that, and because of September, and because of January, it must be February. You cannot do that in law. That's contrary to our principles. The third point is that we will also deal with where the state made a submission, say, but he was not anxious there and there in certain circumstances, but he refers to situations where the accused was not confronted with danger. An anxious person and a vulnerable person does not walk around and show his anxiety and his vulnerability all the time. That will come to the fore when there's a danger or a perceived danger. Just to correct that.
Just repeat that.
The state made a submission and also in the heads and say, but it was a good evening, there was nothing wrong, there was no reason for him to be anxious. Now, where's this anxiety now coming from? And all we say, when you consider anxiety and vulnerability, you must consider it in a context of danger or perceived danger. It won't manifest just in a normal walk of life. When a person goes to bed, he may go to bed and be happy and be smiling. It's not to say 2 hours later when you wake him up and he perceived dangers, that because he was happy and smiling 2 hours ago, he's now not an anxious person. It depends on the anxiety and on the evidence.
Yes, but was that the evidence of one of the aspects?
That was a submission made that I'm just responding.
No, I understand the submission. What you're telling me is it depends.
Yes, no, but it was the evidence.
It was the evidence.
Professor Scholes told us so. He says,
yes.
You have the 2 Oscars. Okay. Yes, it was right at that point. He explained to us the 2 different Oscars. One that you will see that's everything fine, and the other one that you won't necessarily see when he's vulnerable.
Yes.
That was the evidence. Then, on the acoustics, if I may just make this point, we will ask the court to carefully distinguish between audibility and, of course, intelligibility. And it's not the same. Once you interpret, it gets to intelligibility. The plain hearing is audibility, and we'll come back to that, and the state was not drawing that distinction when he referred to the evidence. Then the state said that we were unfair in the heads to say that or to complain that in his cross-examination that he repeatedly called the accused a liar. He said he went through the record and he could find one place. It's not so, my lady. Can I just give you a couple of page numbers? Mm-hmm. It's page 1548, 1550, 1685, 1621, 1743. I will repeat them again. 1548, 1550, 1685, 1621, and 1743, where he said to him, "You are lying." And I did not get to all. I just thought, let me give you a number just to answer that otherwise the impression is that we misled the court by making a submission not backed by the evidence. And then the other principle is really important, my lady, and that's the failure to call witnesses, where the state submitted and referred to the case to say that the state is not there to play chess against itself. That was the submission. It's very different in this case. It's very different. And if I may just make this submission, Van Rensburg and Van Staden did their best to create the impression that they were alone at the crucial time in the beginning. Later people came. And we exposed that by presenting affidavits in the cross-examination of police officials saying, no, that's not true. We were there and upstairs. And this is what we saw. We saw the gun in the bathroom and so on and so on and so on. So it's not just to say you don't have to call a witness. It is in situations where the state is in possession of affidavits by other policemen saying it's not true, we were there. And then what the state does is to call one policeman to say, I was the only person there at the time. Then it's very different from playing chess against yourself. Then we get back to the without fear, favour and prejudice principle and say, but you know from your docket statements that is not correct. And that's where the failure becomes important, to call those witnesses. The second part of that is also crucial. We know that Hilton Botha was the investigating officer. We also know, and I will show it to you in the bail application, that he told blatant lies to incriminate the accused. We'll point that out to you, what he was doing. And we know he was in that bedroom. And we invited the state and said, where is he? Why don't you call him? And we got up in the evidence of Colonel Van Rensburg and said, tell us how you're going to call him. And he says, well, I don't know. I haven't made up my mind as yet. So it's not just a matter of not calling a witness because you're not playing chess against yourself. It's a crucial witness in that principle that's not before court. The third aspect is you cannot dump, for lack of a better word, a police official on the defense and say, you call him now, and then wait and see how accommodating he would be when the state cross-examines him. Now he concedes everything. That's not what a criminal trial is all about. But to show to you, may I demonstrate to you the seriousness of this aspect. It's in the fourth point where the state says the defense relies on this conspiracy. Who would take the fan and move it? Who would take the duvet and put it down there? Where's this conspiracy? It was never put. My lady, may we make it clear? We're not talking about a conspiracy. We're talking about difficulties that you would expect items to be at place A and it's not. And can I take you just through one? And that is this. It was common cause. And I can give you the page numbers, but one I want to give you, it's page 1684, I repeat, 1684 lines 16 to 25. And it was repeatedly put to the accused, and the accused accepted it. With that silver fan, that tripod fan, standing in front of the tripod, standing in front of the sliding door, you cannot get onto the balcony. So you lie if you say you ran out onto the balcony to shout, to help, because you cannot, it blocked your way. That was the evidence, and the accused said, I agree it's in my place there, but that's not where it was. Now, this is the evidence. Now, let us consider in that context a not smaller Colonel van Rensburg. His evidence, I'll give you the page because we'll get back to that. That's page 834. He says, with his first walk through, he was in the bathroom, then he walked through the bedroom, and then he walked through the sliding door onto the stoop, or balcony, he used both words, the stoop or the balcony. And he says in re-examination, I don't know if the fan was on or off. Now, my lady, that's the point we're making. If that fan was there early that morning when Colonel van Rensburg was there, how did he walk through that door? And how did he not, A, the fan was blocking, that's the state's own case, conceded by the defense, and B, if that fan was on, so much the more if the fan was there, he would have known it. He doesn't know about it. So it shows inadvertently things could have moved. The police come in, the fan is right between the radio and the bed. It's in their way. They didn't think at that time something would turn on a fan. Why would they have thought that? Move it away. I can understand it. I can understand it, and that's all the accused was saying. It's not there, and if we think it did not happen, let me remind you of two incidents. Warrant Officer van Staden tells us, I picked up the carpet. He referred to this as the mat. I picked up a carpet, and there I saw the white telephone. Before the photos. He did that, so they picked up things. We know it. We know things like that happen. So, and that's the difficulty that we have in the case. And we say what the state does now, to say, you come with this conspiracy theory. You come with that. Show us, why would the police move the fans? My question is, how would they have moved through there? It was in their way. And if the fan was in the door, in the sliding door, how did Mr. Van Rensburg, Colonel Van Rensburg, get out? It shows there's a problem. And I accept I'm not screaming at the top of my voice, conspiracy, conspiracy. I'm saying they would not have known at that time that there was significance in that. But it was disturbed. And now to blame the accused and to say to him, but you must now be rejected. You're a liar through and through because the fan is not there. Let me take you to another one that we dealt with, and maybe it's the appropriate time, my lady. The extension court. It was put to the accused on a number of occasions. Look where the extension court is. Now get back to it. That's photo 55. It cannot reach. If it was there, it cannot reach. So if you tell us, and you tell the court that your fan was plugged in there and you moved it to where the duvet is now, it cannot reach. That caused us, my lady, to say, hang on. Please give us that extension cord to see if it could not reach, to see if it could not extend. We received in the last moment an affidavit by Constable LaRue saying, well, I used that extension cord and I put it somewhere in the room, and we complained. We say, well, there's a video, we don't see it. But that's all resolved, my lady. That is all resolved because we asked the state, please show us a photo, if you have, how it was plugged into that extension cord. Please show us that. And he did. We got it yesterday. And we're going to show you a photo, but what that photo shows you is that the extension cord is now longer. It's now at the foot end of the bed. It can reach. And the state must have known it because it's a photo in the possession of the state. And that's our concern. How do you put to an accused that you must lie because it cannot reach? If that's its position, it cannot reach. It cannot. When you have at the same time a photo showing that it in fact moved further on, it reached. We'll show you that photo. We need to connect it, but it comes from the state. The last problem there, Colonel van Rensburg tells us, I did not touch anything. I say, please repeat, make sure that you understand. Did you touch anything? No, I was just walking around. Then we show him a photo, that's Exhibit 00, that we will show you again and make it quite clear. And there he's sitting with his hand on the plug of the on the clipper. He sits with his hand on the plug. I can't say if it's plugging it in or plugging it out. What I can say, it's contrary to his evidence that he didn't touch a thing. His answer to that is not, I test the clipper. He said, I was testing the linkage to the fan. It's not true. We'll show you the photo. His hand's on a different plug. So now the state tells us, or tells the accused, you're a liar. You're a big liar. There is no space for that plug. What he doesn't tell us is that we don't know what the position was with the multi-plug at the time. We don't know when that happened because we can't find the time on the photo. We see that the curtain is different than before. So those are the difficulties. We're not saying conspiracy. We say the scene was disturbed, and what you cannot do, my lady, is then make the accused a liar because of the disturbance of the scene by the police. That is the difficulty. But everything I've submitted this far, my lady, will show photo and the parts in the evidence to support what we're saying. The second part, if I may today, my lady, is this. In trying to understand the state's case, and we made that statement to say it's self-destructive. Because on the one hand, we made that statement, but I'm going to illustrate a number of submissions today to support that again. Where the state would on the one hand say, but Mrs. van der Merwe heard the argument, the woman talking, the female talking, and then the shots. And then we hear, on the other hand, the screaming, the terrified, blood-curdling screaming, and then the shots. They're not the same. They're not the same. It can't be the same shots. Because if there was the blood-curdling screaming before the shots, then Mrs. van der Merwe would have told us that. May I just correct one thing whilst we deal with that, and you referred to that, my lady. At one place in the record, and I will show you, you said Mrs. van der Merwe was maybe in and out of sleep. The difficulty came in with this. If you would just make a note of that. And that is in page 159, if I may ask you just to consider this. Where the word is used by the interpreter, she woke up. Correctly, it tells you she was sleeping. She woke up. But that's wrong. We've got, remember, we also made available, my lady, the other transcribers, where you have the Afrikaans. That would be on 225. She was meaning to say, I got up, not I woke up. Ek het opgestaan, I got up. So she was not sleeping. She was trying to sleep. She says that, even by putting the pillow on her head. But she says, I got up in Afrikaans, and it was translated as, I woke up. If I may just deal with the corrections, the state submitted that on count 3, and you would have seen the heads, my lady, I'm not crossing big swords on count 3. I'll say it now, and I say it in the heads, the accused was negligent in the way he handled that firearm. And we'll come to that. So there's no running away from blame there. But what I say, because it's important how he was negligent, is a state submission, that it was never his version or anyone's version, that what happened, how did the gun go off? my lady, it is. It's a state witness's version, and you will find that when we get there to the heads of argument on page 13, dealing with the count 3, where Mr. Larina said, I do remember Oscar very clearly saying, apologizing, is everybody okay? Is everybody okay? I apologize. I do not know what happened, how the gun went off. It was a mistake. I'm not saying that we're going to try and run away from blame there, but I say insofar as the statement was made to you, the submission, that there was no such evidence, that's not correct. That was the evidence of Larina. On the count 4, also not dealing with count 4 in its entirety, just this. The state submits to you that there's strict liability for possession. My lady, there are so many cases on our constitutional approach. You do not have strict liability anymore. It is interpreted with culpability, and in the case of the firearm, you don't need intent. Negligence is good enough, of course. But what you cannot say when you go to the possession element, we've referred to cases. That's the case law. It's saying possession consists of 2 legs, detentio and animus. And we dealt with this. And ultimately, it's for the court to decide on the facts of the case. And it's going to be a difficult decision because it's a legal decision, where he says, I had detentio, but not the animus, because my father put it there. It's his ammunition. I can't even use it. And then, as a matter of interest, my lady, the Firearms Act, the applicable act, contains no provision that you must place a firearm in your own safe. It talks about a safe. Never, ever, it must be in your own safe. But we'll get to that. My lady, then, when I said I was dealing with what I call self-destruction, I dealt with how can you on the one hand say that there were shots after an argument, and in the next moment you say there were shots after terrified screaming. They're not the same time. Both can't be the shots. But the state goes further on other aspects as well, my lady. It says now in the heads, they were downstairs, eating downstairs, 1 o'clock in the morning. And then they had an argument. And then Ms. van der Merwe would have heard. Now, I don't know on what evidence the acoustic situation would have been better there than upstairs. Let's forget about the fact that there's no such evidence. But let's work with the problem in that statement. If that is the state's case now, that they were sitting downstairs, eating, 1 o'clock in the morning, and arguing, what must I make with the statements in the trial that she hurriedly got rid of her jeans? That's why they were so crumpled, in trying to get away from him. Does it mean now it doesn't fit in, my lady. It can't be both. He says that in his submissions that she was standing in front of the door. She did not know that she was going to be shot. They were talking. That's why she was not hiding. That's his submission. Then I say to myself, what must I now do with this blood-curdling, petrifying screams? How does that fit into them talking? Where that screaming started from 3:12 to 3:17, according to the witnesses' notes of Mr. Johnson. It cannot be the same. You cannot stand there talking, and she's not scared because she did not know that she was going to shot, and stand there in front of the door, as opposed to the petrifying screaming. Both can't reconcile. The state also says that the duvet was thrown on the floor in a desperate attempt of the deceased to run away, to flee. That was one of the statements. But now, if they're downstairs, eating downstairs, and there's now the argument, how does it now get to the deceased jumping on a bed and throwing the duvet off? It doesn't correlate, my lady. So, and all these difficulties appear in the state's case because they are forced to vacillate. And that vacillation started, my lady, when the state realized in Dr. Stipp's evidence that after the shots, the deceased could not scream. It was after that, for the first time in this case, that the state, Mr. Nell, stood up and said, let me put it on record. We say that the shots were the second sounds, the 317. It had to do so. He had to do so. And there's a simple reason for that. Because he realized all the evidence of a female screaming would be impossible after the first shots. So he had to move the shots from the first shots, van der Merwe heard it, the 4 shots, to the cricket bat sounds, the 3. He had to move it. Otherwise, all his witnesses were discredited. The difficulty, of course, remained. What would he now say about the first shots heard by van der Merwe, the 4 shots? What would he say about it? What would he say about the first shots heard by Dr. Stipp and Mrs. Stipp? And what would he say, when did the cricket bat happen? He can't. And it's the state that's presenting the case. It's the state that has the onus. We understand, we know the cases, there's no duty upon the state to close every avenue of escape and fanciful possibilities must be ignored. That's not what this case is about. It's an avoiding of material, objective facts that's causing the difficulty. And then we must look at Blom's case. And Blom's case is still from 1939, the law. And it says, if your case is based on circumstantial evidence, which is the state's case, then you need 2 things. 1, you must show that the proven facts only justify one inference and that it excludes all other reasonable inferences. We're not talking about fanciful inferences. All other reasonable inferences. It must exclude that it was not an argument. It must exclude the first shots. It must ignore it on the state's case. It was not there. We must forget about the cricket bat noises because the state could not talk about it. What did he say about it? When was that? What did he say on the objective evidence to you? It was 3:17. We all agree the second sounds. We say it was a cricket bat, just after 3:17. We know the first call was made at 3:19. The second call at 3:20. The third call at 3:21. The fourth call at 3:22. We know then Johan Stander, Carice Viljoen, and Mr. Baba were there. They saw him coming down to 3:22. We know that because we could measure it against objective evidence. When would the accused have been able, if the 3:17s were the shots, when would he have been able to do all the things he had done? It cannot fit into that time frame. It's impossible. But the state ignores it. The easier way to say, don't look at minute contradictions. They were good witnesses. And Mr. Nhlengethwa, was he a good witness, my lady? He was brilliant. And Mrs. Nhlengethwa, was she a good witness? Did he say she was not? She was brilliant. Don't know the accused. What about Mrs. Mochwane? Brilliant. And we will show to you tomorrow that crying out loud in their description happened exactly the same time as the screaming heard by the other 4 witnesses. Exactly the same time. We will pinpoint to you the times when it happened, and there could not have been other screaming. So what did the state submit to you? The state having to prove, having to exclude other reasonable possibilities. Why did they not talk to you about the evidence of the immediate neighbors? Why did they not say, but they said, actually, it's not right. It's not a female screaming. It's a male in a high-pitched voice. And they imitated that in court, two of the witnesses. Where is that in the heads? The state cannot deal with that. It's unable to deal with that. And again, is unable to deal with material, objective evidence simply because he chose to move the shots from the first shots to the second sounds, because he knew that the second sounds would destroy his witnesses. And that's the difficulty in this case. And that's why we hope tomorrow, my lady, to take you through the evidence. I promise not to read the heads out. I will do a principal approach, but take you specifically to the timeline to show to you what we did with the timeline, if I may say. We ignored say-sos. We only accepted the say-so of a witness when it was corroborated by objective evidence. So we took the telephone data, all the objective evidence, and put that together, and then measured the evidence against that. And when that evidence, the evidence was consistent with that, we accepted it. So the timeline we drew on objective facts, or oral evidence supported by objective facts. So it's not that we choose the timeline. It's there, and what's important about that, my lady, you will see a witness there. I've seen it many times in my life. He's quite impressive. I sort of like him, and I think he's credible. And then I go and sit in the quiet of my room, and I read his evidence, and I start to weigh it against objective facts, and I say to myself, what's going on here? And that's why we have tests in law. May I give you, it's the last point that I make, a small example about Dr. Stipp. He tells us about the accused shouting, help, 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 at a time when no one else had heard it. And we will show to you, because we have his telephone data, when he said he made calls, that that was after 3:30. To give you an example, and he appeared to be quite impressive, Dr. Stipp. Help, 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 after 3:30. My lady, at 3:30, he was a long time at the house of the accused. He admits that when Johan Stipp phoned 911 at 3:27, he was there. He'd already examined the deceased. He'd already phoned Wilgers Hospital, standing next to Johan Stipp, and then, Stander, and then Johan Stipp phoned, Wilgers said, no, you must phone 911. And Johan Stipp at 3:27 phoned 911. Then we know, he was at least 7 minutes there. We don't think that because Peter Barber told us that he went to his house and Dr. Stipp then followed shortly thereafter. And Peter Barber arrived at the house at 3:22 when he phoned the accused. He was outside and he saw him coming down. So we know it. So all we say is once you measure the evidence against objective facts, you realize that there's a difference between reliability and credibility. We don't always say a witness is not credible. Many times that witness genuinely believes what he or she is saying. That's not the test. Is that what he or she is saying? Is that reliable? And there's one way to find it out. Measure it against objective evidence, and that's the exercise we've done in the heads. And that's what we do in the timeline. And once we've put that before you, we say that it will open up, and then we can deal with the legal principles to see where the accused conduct should fit in terms of the law. What defense can you look at and what can you not look at? Would it be appropriate to stand down till tomorrow, my lady? May I inquire, my lady, will it be 9:30, the normal time then?
It's 9:30 tomorrow morning. The court will adjourn.
Yes.